family of Todd Bagley would like to thank President Donald J. Trump, Attorney General William H. Barr, and the Department of Justice. Without this process, my family and I would not have the closure we needed to move on in life. It has been very difficult to wait 21 years for the sentence that was imposed by the judge and jury on those who cruelly participated in the destruction of our children to be finally completed. The local news gave one of my statements, and I appreciated the way they presented my quote: "When someone deliberately takes the lives of others, they suffer the consequences of their actions. This senseless act of unnecessary evil was premeditated and had many opportunities to be stopped at any time during the 9-hour period. This was torture as they pleaded for their lives from the trunk of their own car. Please remember that the lives of family and friends were shattered, and we all have grieved for 21 years, waiting for justice to finally be served. Thank you to all who were involved in this process of getting justice for Todd and Stacy." And I would also like to add that the apology and the remorse that was shown to the family and the fact that they regretted their acts at that time helped very much to heal my heart. And I can truly say I forgive them.
A heartbreaking moment and a moment of reality. You know, last night we covered in great detail the execution of Brandon Bernard for the murder of her son and her daughter-in-law, Todd and Stacy Bagley. And there you saw the reaction from Georgia Bagley. And you know, it's heartbreaking, but in the end, there was a sense of closure for her. And one of the arguments always against the death penalty is that, you know, these cases, they come up again, there's hearings, there's appeals, and it's almost like it's torture for the family. But when the execution does actually take place, that's it. I mean, it's over. The family can turn the page and can move on. You know, this is interesting because this is a federal case. And for 17 years, there were no federal executions. And now it's been reinstituted by President Trump, his administration, and the Department of Justice and Attorney General Barr. And there have been several, and there's more scheduled for this year. Let's bring in Court TV anchor Michael Ayala because it continued actually tonight, the day after yesterday's execution. There was another one today.
Yes, Vinny, another execution took place today at the Federal Correctional Facility in Terre Haute, Indiana. At about 6:40 this afternoon, we got word that the Supreme Court had denied Alfred Bourgeois' last-minute request for a stay of execution. For just the second day in a row here, Justice Sotomayor, she penned a dissent. She was joined by Justice Kagan. That left 7 in agreement, and it only takes 4 to deny a stay. But, Vinny, in this case, there's really no denying that the facts are horrible. Alfred Bourgeois was a 55-year-old man from Louisiana. He was a truck driver, and in 2002, he sexually abused and killed his 2-year-old daughter on federal land in Corpus Christi, Texas. Now, while this case didn't garner the same publicity and support as Brandon Bernard's case, the one we've been talking about the last couple of days, it's okay. Now, this case is still very, very important, and it's notable, Vinny. And that's because Mr. Bourgeois had an IQ of 70, which under law is mentally disabled. Now, in 2002, shortly after he was convicted and sentenced, the Supreme Court ruled that people with IQs that low, while functional, are less culpable for their crimes and therefore should not be subject to the death penalty, that it amounts to cruel and unusual punishment. The problem in this case, Vinny, is that the original defense team never presented evidence of his disability to the jury. His appeals attorneys, they got him tested. They took the results to an appeals court, and the court rejected their request for a new hearing. The defense appealed that. They were actually granted a stay. That court said they had a strong case, but they sent it back to the very same court that rejected them the first time. They rejected them again, saying that the issue had already been decided. His defense team appealed that to the Supreme Court, and as I reported earlier, they denied that writ of certiorari, allowing the execution to go ahead as planned. Now, earlier today, I spoke with his attorney, about the case. He said Alfred was remorseful, he was hopeful, he was having trouble truly understanding what was coming, but he was remorseful for his crime. But I really talked to him about the difficulties in getting this case heard. So let's take a listen.
As of this point, no jury has ever heard the issue regarding his intellectual disability.
That's correct.
Okay. And so subsequently, you got him tested, you tested his intellectual disability. Tell me how that went and what that showed.
So we were appointed to his case about maybe 13, 14 years ago. And we hired a psychologist to do intellectual disability testing. At the time. It was known as mental retardation, so IQ testing. And he was tested and his IQ was 70. 70 is in the borderline intellectually disabled range, in which the US Supreme Court said 70, you cannot be executed. But this was after his trial, so the jury never heard this evidence. We presented that evidence to federal district court in Texas. The court, using outdated standards of how to assess that evidence, dismissed our claim and said we had not proven that he was intellectually disabled.
He's someone who seemed to be living a life. He had a partner, he had a child, he was driving a truck. Someone could objectively look at that situation and just say, how is that person not intellectually capable of understanding his crime or understanding his punishment?
Well, intellectual disability is not a situation of understanding your crime or your punishment. This is not a case where we're saying, like the McNaughton standard, where someone is insane and they don't know that they're doing something wrong. This is not like that at all. And if you look at the case that the Supreme Court decided in 2002, that's what they said. They said this is a standard by which we have decided that people with mental retardation should not be executed because they are less culpable. It doesn't have to do with understanding or any of those things. However, psychologists will always say that someone with intellectual disability would have strengths. People can drive. We all know people that may have intellectual disability, that may have a driver's license. And those are things that are fine. But the courts in Texas, what they were doing was relying solely on those things and not properly assessing what the weaknesses were and what the intellectual disability standards are in 1996.
As a layperson looking in, they would say to you, you obviously have a legitimate claim, but yet the court has blocked you from getting that claim heard. And I heard you mention successor claims, and I understand that, but I want you to explain what successor claims are, what the standard is, and why you cannot get what appears to be a legitimate claim back in front of a court to save someone's life.
Well, so in 1996, Congress passed a statute that made it very difficult for capital defendants to get back in court on either new evidence or on new law. And basically there are two ways that you can try to get back into court on a successor habeas. And one is if there is new evidence establishing innocence of the crime. And so that's one way you could do it. We're not suggesting that that's part of this case.
That would be something like DNA, for instance.
Exactly. Like if DNA exonerates your client or something like that. The other way is a new rule of law that's been made retroactive by the US Supreme Court that you can go back in. So we argued that that's what this is, that the Moore decision was a new rule of constitutional law. However, some courts would say, well, it's really just based on Atkins, which came out in 2002. And they, courts find narrow ways to deny successors. They almost always deny successor habeas litigation.
Now, Vinny, after the execution this evening, I did get a statement from one of the other attorneys on the defense team, Victor Abreu, and he said tonight, the United States killed a man with intellectual disability in spite of clear directives from the U.S. Supreme Court and federal laws that prohibited it. He said it's shameful that the government executed Mr. Bourgeois without fair consideration of his intellectual disability. The fact that he was executed without review taking place, even though he is categorically ineligible for the death penalty, shows why the government's haste to execute so many people in the midst of a pandemic and during a lame duck presidency is simply unconscionable.
All right. Michael Ayala, appreciate the report. Important stories that we're doing here. Thanks so much.
You're welcome.